According to the court, since the repeal rule was outside of the DOE's statutory authority and did not fulfill the requirements of the policy, that policy is arbitrary and capricious and therefore did not comply with the Administrative Procedures Act. In sum, it is unclear that DOE has any statutory authority to regulate water use in dishwashers and clothes washers. But even assuming the department has that authority, the repeal rule is arbitrary and capricious for two principal reasons. First, it failed to adequately consider appliance performance, substitution effects, and the ample record evidence that DOE's conservation standards are causing Americans to use more energy and water rather than less. And second, it rested instead on DOE's view that the 2020 rules were legally invalid, but even if true, that does not excuse DOE from considering other remedies short of repealing the 2020 rules in toto. While the striking down of the repeal rule is a good thing, there's one very important point the court missed. While the court looked at the statutory power of the Department of Energy, they never looked at its constitutionality. Congress stated the purpose of the Energy Policy and Conservation Act of 1975 within the legislation. The purposes of this chapter are to grant specific authority to the President to fulfill obligations of the United States under the International Energy Program, to provide for the creation of a strategic petroleum reserve capable of reducing the impacts of severe energy supply interruptions, to repeal Title I, Section 1022, to conserve energy supplies through energy conservation programs and, when necessary, the regulation of certain energy uses, to provide for improved energy efficiency of motor vehicles, major appliances, and certain other consumer products, to provide a means for verification of energy data to assure the reliability of energy data, and to conserve water by improving water efficiency of certain plumbing products and appliances. Look all you want, but you will not find the power to conserve energy supplies, improve energy efficiency, or conserve water as a power delegated to the United States. You may be thinking, but what about the International Energy Program? That was probably done by a treaty, which makes it the supreme law of the land, right? No. The Supremacy Clause states, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land." Only treaties made under the authority of the United States are the supreme law of the land. The United States does not have the authority to regulate energy or water supplies. Therefore, any treaty that may have been signed is not within the authority of the United States, not the supreme law of the land, and as an unconstitutional act, void. In fact, since regulating energy is not a power delegated to the United States, the legislation that created the Department of Energy is an unconstitutional act and therefore also void.